Finally, the listed offences. There are around 143 offences which the Integrity Commission could investigate to. They're listed at section 18 of the bill, and this bill also creates new offences of repeated public sector corruption, concealing public sector corruption, public disclosure of false or misleading allegations made or information given to Commonwealth investigative body, diverting resources of Commonwealth investigative bodies by making an allegation or giving information that is false or misleading, and notifying public sector corruption issues with no basis and with an intention to cause detriment. When the Law Enforcement Division or the Public Sector Division investigated pursuant to the standard of corrupt conduct or any of those 143 offences, the existing capacity of the Law Enforcement Integrity Commission would exist and be subsumed into the new agency, so they could hold both public or at their discretion, private or at their discretion public hearings. They can deliver reports on matters that they investigate into. The public sector side of the Integrity Commission is not designed to make public reports. It is designed to create briefs of evidence on any of those 143 offences in the public sector, which would constitute corrupt conduct, which would go to the DPP for public trial and conviction or acquittal, depending on how that trial transpired. Finally, the to-be-created Commonwealth Integrity Commission would report to, so be a part of the Attorney General's portfolio. It would be oversighted itself by an independent Inspector General, which would be a newly created position under the Act, and it would be oversighted by a standing parliamentary joint committee, and all of its coercive and investigative powers, so that is its ability to intercept phone calls and so forth, would be oversighted, as is usual with these things, by the Commonwealth Ombudsman. So I'm sorry if that's taken a little bit long, but that provides you with the 5 sort of central issues, I think, that arise with respect to the Integrity Commission. We will now embark on what I imagine would be a 6-month or so period of consultation. That'll be obviously amongst the public sector, civil society, stakeholders, all of the states and territories. I'd hope to hold roundtables. It's a complicated piece of legislation. It may well be that during that consultation process, some of the interfaces and interactions with the existing agencies are subject to scrutiny, and I'm not saying that this bill is beyond any improvement, but I think that gives you a description of how it will operate.
Can I ask quickly first up on public hearings? Are you saying that the Public Sector Division would not hold public hearings at all, would it have no discretion to hold them? And are you open, through this consultation process, to the argument that critics of your model are going to make, where they say, look, it must have public hearings?
So the Law Enforcement Division will maintain its discretion to hold public hearings. This draft does not propose public hearings for the Public Sector Division. The rationale for that on the government's part is that there is a higher risk and a much greater threat from corruption inside law enforcement agencies, insofar as they are the agencies that are meant to enforce the law. And so having that discretion, which has never been used, I might add, by the existing ACLE to date, is appropriate in that division. We do not consider that a body with this type of power should be having at its discretion the ability to hold public hearings. Now, that's the government's position. I know some people agree with that position. I know some people disagree with that position, but we will obviously be having all of those arguments ventilated in the context of this very detailed draft. But the government's position is that to not repeat some of the mistakes at a federal level that have occurred at a state level, it is a fair and reasonable thing to note that the public part of the process will be in a court once the Public Sector Division has used a powers greater than a Royal Commission to investigate anything that it considers evidence as a reasonable suspicion of corruption, put a brief together, have it investigated and have it openly ventilated in a court.
Forgive me if I missed it, but does it have the power to launch investigations on its own volition?
It has referrals from all of the existing agencies. Its own motion powers attached to instances where it has something already under investigation that has been referred and something else is revealed to it, the Integrity Commission, through the conduct of its investigation, then it can pursue those avenues, if I can put it that way. But there is a filter mechanism for referrals through all of the existing agencies that exist.
Attorney, how soon could
I might say that the Law Enforcement Division will still be able to take direct referrals from the public.
Attorney, how soon could the Public Sector Integrity Division be up and running? And what would you say to a cynical person who could note that for politicians and public servants, integrity will come later and it will come weaker because the jurisdiction will be limited to things that are suspected as crimes?
Well, it's a very, very long list. So I would say to people, have a look at all of the matters that are on that list. I mean, in my observation, they cover virtually every conceivable type of serious criminal conduct that one might label corruption. Again, people might take different views about that and those views will be ventilated. But the idea that I think is inherent in your question, that urgency attaches to some state of affairs that exists at the moment, there are 11 different highly motivated and highly resourced agencies that look into issues of integrity, criminal offending and corruption across the public sector at the moment. The government's view is that that machinery that has long existed and successfully existed, being a multi-agency approach, can be improved with this sort of model. But this is something over the top of and integrated into a system that largely, I think, has worked relatively well.
So when will we see the scrutiny of politicians? When will we see that Public Sector Integrity Division up and running?
Well, that is a question for the passage of legislation through Parliament. And part of my process and role here is to speak with the crossbench, whose role will be very important in the passage of any legislation, about this very detailed legislation, listen to them, consider their views. Also, I would imagine try and convince them that this is the best balanced approach to creating an agency of the most unheralded type in terms of its coercive and investigative powers that has ever existed at a Commonwealth level.
So the fundamental role of this, if a politician is accused of corruption and referred, does the CIC fundamentally investigate, create a brief of evidence and refer to the DPP rather than actually make rulings itself?
Essentially, I think that's a fair description. But if a member of Parliament or their staff or any other public servant for that matter had attached them a reasonable suspicion, then at the moment those types of issues would be dealt with by the Ombudsman or the Independent Parliamentary Expenses Authority or the AFP. If any of those 11 existing agencies had a matter referred to them that they considered involved a parliamentarian or a public servant in a way that they thought it should be referred to the Commonwealth Commission, then they would do so. And the Commission would sit as a specialised, incredibly well-resourced, both in terms of its staff, its budget, but its powers, agency to specialised in the investigation of those sort of matters.
And is that made public when something's referred to, if something's referred to the CIC and there is a politician under investigation, will that be made public under this legislation?
Well, the investigation is a matter that is at the hands of the Integrity Commission, and they would exercise great care, I would imagine, so that's a matter that they would determine.
Just trying to pick some of the things you've said. Is it correct to say that the threshold for investigation, say AFP officers or someone from Border Force, is lower than the threshold for ministers and bureaucrats? And if so, why is that the case, given the consequence of corruption of a politician is perhaps greater than an official in AFP or Border Force?
Well, the standards for investigation, which are always based on reasonable suspicion, are different. Now, whether you would describe them as lower, I'll leave to the public debate that will exist on this. But the existing ACLI Act has a definition of a thing called corrupt conduct, which sits in, I think, Section 6 of that Act and will be transferred over to Section 17. That definition, the meaning of engages in corrupt conduct, talks about abusing office, perverting the course of justice, and talks about corruption of any other kind, which is a very broad term. One of the difficulties that has arisen with state investigative bodies of this type is that where they have a breadth over that type of jurisdiction, there's been great confusion. Sometimes minor matters have been scooped up. Sometimes people's lives and reputations in the public sector have been destroyed when there's been no prosecution or indeed an ultimate finding of the Commission has been reversed. So with respect to those hundreds of thousands of people, which include politicians, yes, The government's position is that the reasonable suspicion should attach to a known offence where the offence has an element of an abuse of public office or perverting the course of justice. Now, the breadth of those offences, when you read the list of the 143 offences, is very, very large, and it includes very broadly worded offences like the abuse of public office itself at a Commonwealth level. So you might argue that the jurisdiction of the Law Enforcement Commission is slightly broader, or you might argue that in the important area where you're covering hundreds of thousands of public servants, including politicians, that there is clarity as to what conduct is criminally corrupt and what conduct might be misconduct or a lower standard.